for like divorce type of situations, right? That's what I envision in my head. So really, you can do mediation for all of these different types of cases.
Yeah, and sometimes depending on the facts, every case is different. So we might want to do an early mediation if we think it'll benefit the client. Sometimes we do pre-suit mediations, but most of the time, once a case gets into lit, it's going to follow that standard process of getting the written discovery done, getting the deposition scheduled, and then figuring out what else we need. If any subpoenas have to come in, we have to wait on more documents or more evidence. And then once we know it's ripe for mediation, where we're going to actually make a meaningful effort to get it settled, because clients want finality. They want it over with. They don't want to go to court. They don't want to wait a year. And sometimes it takes a year or two to get these things done. So we're doing everything that a lovely law firm can to work these things up from the day we file that complaint to get to that point of mediation, to get the money in the client's pocket as fast as possible.
So it may not even need to go to trial after that.
Well, that's the goal, if we can resolve it. But I mean, there's instances where they're going to lowball us, and it's not full and fair, and clients may even tell us, I want to settle it, and we say, look, we cannot take this offer for this case.
Yeah.
And every case is different. And if that's the case, we'll take it to trial if we have to.
Okay. So tell me, if it does go to trial, what is the roster system?
I'll take that one. So the roster. And this is something that's kind of unique, because I grew up in the Tennessee court system, and then I came down here to South Carolina. But this is how, at least in the state courts, we're going to be set with a roster. And what a roster meaning is you file a complaint. Let's say we file a complaint today. Okay, well, we're not going to get on that roster. And what the roster is what's going to trial that week. So we're not going to get on that roster for a year and a half to 2 years if we filed it today.
Wow.
And that's pushing it hard. And now the court system has done a good job of moving cases since the COVID backlog. But we're still a year and a half out from trial. Crazy. So what that means is they'll send a list of cases, and it might be 40 cases on the list. But just because you're number 40, you might go to trial because dockets fall apart, cases get settled. But they won't give you a date certain. Sometimes they will. You have to file a motion, try to get a date certain. But the roster system is essentially, hey, you're on the roster now, and you might be number 1, you might be number 40. It just depends on what's on that county. And we meet, and the judge is basically trying to figure out who's going to trial this week. How long is it going to take? Is it a 1-day trial? Is it a 3-day trial? Is it a 2-week trial? And he'll go down there and he fills the trial courts up. So he or she, depending on what judge we get. So they'll fill the trial rosters up, and then the trial dates for that week or that 2 weeks, whatever the term of court is. And then they do that every term of court. And that's basically, it's like a rolling cycle. So even though you're 40 on it, this roster, maybe next roster, you're number 3 or number 4.
Okay.
And you got to be ready to go to trial.
Right. So you can't wait thinking like, I got a year to get more evidence and stuff.
We start preparing for trial when we file that complaint.
Okay.
You can't wait.
Right.
Because if you wait, you're scrambling. You won't have a complete case file. And we have the burden of proof as plaintiffs. We have to prove the case. So we can't be messing around, delaying. So JP and I and Sarah, we're always rocking and pushing things as fast as we can.
Well, let me ask you this. So, with going to trial and getting a trial date, do the courts ever push certain cases up depending on what they're about, or do you just file in line?
Well, it's not really what it's about. I mean, but if you have a complex case and they got a certain judge and everybody's in town and they need to try that case, that's something that would be discussed at that roster meeting.
Gotcha.
If a docket falls apart and we got 2 soft tissue cases he can try in one day, a judge is going to say, hey, you're going Tuesday, you're going Thursday. Because we also don't want to waste the jury's time, right?
Sure.
This jury pool's coming from, they're pulling people from Horry and Georgetown counties, and we got to get a jury pick. Don't want to waste their time. If they're going to be around, they got to be ready to be set and move the court system along.
Okay.
And if things don't go to trial, it just keeps the backlog going and going and going.
Man, that's crazy. So you really got to be patient with stuff like this.
We don't like to be patient.
Right.
We want to push it.
Right.
But sometimes you do need to be patient.
Yeah. Well, from the court side,
Yeah.
you have to be patient. So, I know that you can sit on that roster for a year or more, but what is the process timeline-wise from start to finish, from even just filing that first, what was it called? Claimant?
The complaint.
Complaint.
So when the earliest you could get a trial date would be 1 year from filing that complaint. That's by law, so we can't ever have a trial sooner than a year.
Okay.
Now, because of, like Justin mentioned, the court system's overburdened. I'm sure everyone's heard about that. You throw on COVID when the court system was closed for a year to 16 months or whatever it was. All those cases didn't get tried, so now they're getting tried now. You have folks in criminal, waiting trial. The same judge that does a car accident case is overseeing a criminal case. So,
wow.
a lot of these criminal folks are getting precedents because they're waiting for their trial date. So we're kind of at the mercy of the court. Once you are on a roster, like Justin alluded to, they're going to set basically 40 cases saying you're up for trial that week. Now, it's in chronological order, 1 through 40. So if you're 40, you probably won't go to trial that week, but you don't know, like you said, if everyone settles. Right. So you have to be prepared. You have to have your witnesses prepared. And you certainly need to have all your discovery done. And, when we were talking about discovery, written discovery is really an exchange of documents. Interrogatories are an exchange of information. It's questions that each party has to answer. And we can come up with whatever questions we want. They have to be relevant, and the other side has to answer them. They're going to send us the same question, similar questions probably, and we're going to have to answer them. Now, one of the biggest holdups that we're experiencing is defense attorneys or, anyone on the other side that we're going against not responding to the discovery questions that we need. Technically, the rules allow for 30 days. Once we send them to them, they have 30 days to prepare their answers and send them back to us. But all too often, 30 days passes, 68 passes, 90 days pass. We don't, and we don't have answers. Now, we'll never let it get to that 90-day mark, but the only recourse we have is first we're going to just reach out and ask the other side, hey, what's the holdup? When are you going to get these to us? And when we don't get a response that we feel is reasonable, we're going to have to take matters into our own hands and file a motion with the court. And that's called a motion to compel. And what that means is we're asking the judge to order the other side to provide us the answers that they're already legally obligated to provide us, but they kind of need a kick in the pants from the judge to actually do it. And a lot of times just filing that motion, the other side doesn't want to have to go in front of a judge and explain why they couldn't respond to it. Sometimes we do have to go in front of the judge and argue. Maybe they do respond, but they do it the night before. And our clients have been waiting patiently for 6 months, and the defense is just delaying, wanting them to just roll over and accept an amount of money that isn't fair and reasonable. And in that case, we're going to be asking for the costs or the fees and anything else that are associated in moving forward in the delay. So motion compels, we file them. Don't like to, but sometimes it's a necessary evil.
Yeah.
When life gets ugly, justice is love.